All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Thank
Be
you.
seated.
Thank you.
Welcome.
Good afternoon and welcome to the Court of Appeals. We have one case on for oral argument this afternoon, the case of Coswalld versus New Hanover County. Your panel this afternoon, to my right is Judge John Arrowwood. To my left is Judge Jefferson Griffin. I am John Tyson. And if there are no preliminary matters, we will hear from the appellant.
May it please the court, my name is Tom Terrell with the law firm Fox Rothschild. I'm representing the appellants Coswalld and Tribute Investment today in their appeal of a denial of a special use permit of a multi-use residential project in Hanover County. I'm joined here today with my colleague and law partner, Mr. Kip Nelson. I don't think that we plan to use the entirety of our 30 minutes, and we do wish to reserve at least 5 minutes for rebuttal. The appeal before the court today has a very narrow focus. Did the neighbors in this case present competent material and substantial evidence that an apartment complex with a small retail component in some way comprise a material danger to the public health and the public safety because of traffic and because of flooding? I can summarize the essential facts in this case in 4 very short points. The first is that this is a 15-acre tract of land, and it has many uses by right, but Tribute had to apply for a special use permit only because they were asking to have a residential component. Second, the project essentially was nothing more than an apartment complex, a very creatively designed, architecturally designed apartment complex with retail not to exceed 7,500 square feet. Number 3, this application that was before the board was what is called a down zoning, where the intensity of this project was far less than what was allowed by right had this developer come in before the county and done what the law had allowed them to do. It had 2/3 less traffic, it had 2/3 less stormwater, according to the experts. And the fourth point is that after all that was done, the Board of Commissioners made its decision based upon the opinions and the generalized fears of the opponents, the neighbors, and ignored all of the evidence presented by the appellant that is before you today. Now,
Mr. Terrell, I understand that there had been a staff review and a planning board review, a DOT review.
That's correct.
And a county engineer review.
That is correct.
Can you cover those in terms of what, if anything, happened during those other reviews before it got to the county?
In all of those reviews, the staff reports explained to the board that they had met their burden of production. The county engineer discussed the stormwater. The county engineer approved of and agreed with the study presented by Mr. Clinkscales. The NCDOT and the Wilmington Metropolitan Planning Organization had all reviewed the traffic study that had come before them for review. They thought that the traffic study met all of the standards that it needed to meet. The planning staff felt that it met all of the standards of the ordinance, and the most interesting thing is that the planning staff says it thought that some of the claims by the engineers were conservative. They thought it, based on what they normally use as their standards, it would create by right use would generate more traffic and more stormwater. So that was what was presented to them. But
So
in this
did
case-
the planning board also vote on it?
Yes, it did, and favorable and recommended.
Okay.
All parties stipulate that tribute investment met its burden of production, that it presented competent material and substantial evidence on all standards, which is significant here because under the rules of evidentiary proceedings, it means that tribute investment met its burden of production and became, in the words of our Supreme Court, entitled to the permit. And then as has happened in dozens of cases, the burden then shifts from the applicant or the petitioner to those who would oppose it to see if they can present contradictory evidence. And that evidence has to be competent, it has to be material, and it has to be substantial, the same burden on the applicant. But it was none of those. Their testimony could not be hypothetical, it could not be speculative, it could not be vague, it could not be a generalized fear, it could not be a lay witness opinion on something that would require of a traffic engineer or a professional engineer's opinion, yet it was all of those.
Did they have any expert testify?
They did not. They did have one neighbor, Mr. Jeffcoat, came in who tried to develop some credibility with the board by saying he works with engineers and he works with hydrologists every day, but that's not the same as being an engineer or a hydrologist. Basically what the neighbors came in with were claims of existing traffic. They talked about the road Lindner. They talked about Market Street. They talked about the surrounding intersections and how aggravated they were. And they showed pictures of flooding from past hurricanes. And that was essentially what they came in with. Now, those facts fall into a pattern of cases that we have seen over the last 45 years, since the Humboldt oil case in 1974, where the applicant comes before a board and they have their appraisers, they have their traffic engineers and engineers, and they present competent material and substantial evidence. And then neighbors come forward, they're angry, they have a lot of emotion that they're expressing, they express a lot of what ifs and hypotheticals, and a board, and sometimes even a well-trained board, will then conflate the anger and emotion into evidence. But of course, that is not the law in North Carolina.
Mr. Terrell, can you explain to the court, you talked about downs zoning.
Yes.
Can you explain what would have been permitted on this property and what your clients were proposing to put there?
Yes. This would have been, the zoning in this case was what is called B2. It's a more intense business zone, and it allows everything from a Walmart to a Lowe's to a Walgreens, a CV, anything like that that would be a very high traffic generator in an area like that. They calculated that it would be up to 116,000 square feet would have been potential. But in this case, in order to have added the residential component, they had to go from B2 to the B1 uses, which are less intense for that commercial component, and they had to get a special use permit to add the residential.
So New Hanover County doesn't allow everything up to that B2. I believe in some jurisdictions, if you've got a B2, you can develop anything under that.
That's correct.
But in New Hanover County, apparently, they do not allow that if residential is one of those. Is that correct?
There are hundreds of zoning ordinances in this state. None of them are similar, and they all have quirks. To me, that is a quirk, that in order to add a residential component, you have to have a special use permit. But that nonetheless was the law that they adopted.
And they would not allow the residential in the, for lack of a better word, a heavy commercial zone.
That is correct.
So is it fair to say the B2 was New Hanover County's heavy commercial zone?
That's my understanding, yes. It's important to note for the court that we have a series of cases coming out of the Supreme Court and this court over the last 45 years, but the law has changed. That law took a huge shift in 2010 when the legislature at the 2009 session adopted a statute that finally codified quasi-judicial proceedings. Prior to that time, it was a little bit of the Wild West, and it was an admixture of a lot of cases with competing analyses. We did a lot of grabbing of language from municipal treatises as to what we should be doing. But finally, we codified that, and we determined, our legislature decided what was and what is not competent evidence. And the most important thing for this case is 168-393, subparagraph K3, which provides that the opinion testimony of a lay witness is conclusively incompetent, whether there's an objection or not, in three situations. And the first is when that lay witness wishes to testify about how an increase in traffic would materially endanger health and safety. The second one is property values, which is not at issue here. And the third is on a matter where you would otherwise in court have to have an expert to testify. And I think this is an easy case here because we do have transportation and professional engineers who do deal with stormwater and with traffic. But what this means is that there are a lot of cases that if you're not careful, there are a lot of cases decided prior to January 1, 2010 that no longer have precedential value because they don't, under a fact situation today, they don't hold up under 168-393.
One of the issues in the case, and there may be a stipulation, I just want to establish it early, and I'll ask the county when they appear also. In the order that reviewed the commission, there was an allegation or a finding that the statute under which the board had said was the inapplicable statute, and that there's been a codification of 160A and 153 into a new zoning ordinance under 160D. Is that correct?
That's correct.
But there was also a stipulation that the provisions that were applicable to this special use proceedings were identical under both.
That's correct.
Is that a fair summary of what?
That is 100% correct. This case was decided before 160D came into effect, but the provisions did not change.
So the text of the statute's the same, just the number change?
Word for word, comma for comma. That's correct. But what this means is you have to look at the cases and the facts to see if they hold up. The county cited 19 cases. Only 3 of those cases were decided after 393 was enacted. And of those 3 cases, only 2 of them were land use cases. And 2 of them that deal with whether or not a lay witness can testify. The Howard v. Kinston and the SBA v. Asheville case would not hold today. So I call that to the court's attention. I would like very briefly to look at both the flooding evidence and the traffic evidence. First, as to the flooding and stormwater. Stormwater in a proper sense is an engineering issue. It's not a land use issue. An engineering study is rooted in many things, as this particular study was. If you look at this study, it's just like any stormwater study. It has statistical data about rainfall over time. It has a lot of calculations of impervious surface. It has a lot of calculations that to me are just math and physics. It looks at topography, the velocity and the volume of water, the size of the incoming infrastructure and the exiting infrastructure, the proper sizing of detention ponds. They used computer modeling to analyze all these, and then they apply the existing state statutes and state standards. None of the neighbors took any of those elements. Not one neighbor looked at those elements that would have been in a stormwater. And as I said, all they did was to talk about how horrible it was in past flooding situations.
What, is it fair to say, and I know that it's argued that the trial judge, Superior Court on a certiorari should not quote find facts because that is the board's prerogative to do that, and that a lot of what's in the order is not really, Judge Jones' order is not really appropriate for a review court,
I agree with that.
where the Superior Court is sitting as a review under either a whole record test or looking at law de novo,
I
correct?
agree with that.
And I'm trying to maybe narrow down to, is the chief focus here, after reading the order, that there are off-site improvements that have not kept up with the need of the area, that are public improvements, roads and drainage, and that your client should wait to develop your property until the roads and the storm sewer, quote, catches up? Is that, when I read the order from Judge Jones, I got the sense that they're saying your client has to wait to do their project regardless of what evidence is presented until the public part, the off-site improvements, meet some standard.
That is exactly what happened. That is applying a legislator's or imposing a legislator's perspective on this. Tribute Investment became entitled to that permit, whether the stormwater or the traffic infrastructure had caught up to where the public wanted it to be. But you cannot, in these types of hearings, you cannot subject the developer to vague and undefined standards that are not in the ordinance. We have cases that say that. And that's exactly what was done. They said, we just want you to wait. But there was nothing to measure that against.
Well, now, in your brief, you had cited some cases that basically said that the public infrastructure, that your rights to develop your property individually are not necessarily based on the public infrastructure either. Is that, and I understand also that during the planning board hearings and staff reviews, that your client had agreed to install additional drainage, had agreed to put sidewalks in, had agreed to upgrade the public streets as they were adjoining his or her premises, right?
That's correct.
So, and they had agreed to those things as a condition to gain the approval of staff and the various review agencies?
That is correct, and they, to my best estimation, were ignored by the board as well as the court.
I don't want to put words in your mouth, but I'm just trying to confirm my reading of the record and then the order.
You have the record correct. The developer offered to supersize the detention pond. Instead of building it by right to a 25-year storm, they offered to do it to a 100-year storm. It would, according to the engineer, it would actually improve the stormwater flow going off of the site by doing that.
Would it also accommodate other off-site areas too?
Yes, it would. And they also said, we will also put a drainage pipe in under Market Street so that instead of flowing into the Ogden community where flooding had been, it would go into a different basin because this site sits at the apex of 3 different watersheds. And so they said, we will send it off in that direction. So they offered to do quite a few things in response to that.
What about the streets and the?
I'm sorry?
The streets and the road, they were all public roads, correct?
Yes.
Except there's one realignment of the side street that some portion of that remained private and the rest became public, or not?
They were required to do a westbound turn lane into the project, but according to the traffic engineer, there would be only a slight increase in traffic volumes for this. So there weren't that many mitigations that were indicated or required by the traffic study. If I could, on the flooding issue, there is one case that's very eerily similar to this, and that's a solar farm case decided in 2017 where neighbors complained about flooding, and flooding was what was their primary concern. And I want to read 2 sentences from it because this is what has happened here. Now, the board wholly ignored petitioner's expert testimony on water management and solely considered lay witness testimony of their speculative fears of worsening floods due to the present state of stormwater drainage and management on adjacent properties. Even if this is true, this flooding is based upon current conditions from the defunct golf course and not due to conditions or uses proposed by the plaintiff. And it then goes on to say that the speculative and general lay opinions do not constitute competent evidence. Judge Tyson, that was your case, the Echo Plexus versus Currituck County, and that I'm quoting from, that is so similar to this case. In my remaining 3.5 minutes, a quick comment on traffic. We have here a focus on potholes. We have a focus on volume of traffic. But in order to proclaim that poor maintenance or a pothole or a narrow road constitutes a material danger to public safety, 168-393 says it is conclusively incompetent unless you can do that with an expert's testimony. And there are, you have to have had something. The neighbors would have had to have had something or someone with a PE after his or her name to say that narrow streets in this case or the lack of sidewalks created a material danger to public health and safety. Now, the record shows very clearly that that was a state road. And the implication of that is that our state has tens of thousands of miles of state roads that have no sidewalks, that are narrow, that do have potholes, that do have some crumbling in the road. And the implication of that finding is that we cannot have or should not have any more development that uses state roads. And I don't think that's the implication that we should be drawing from this case.
Isn't that some of the same logic that the DOT used on the MAP Act cases?
Yes, it is.
That, you know, you cannot use your property as long as we have 2 lines on a map that
Yes,
may
it is.
result in some road in the future?
Yes, it is. Yes, it is.
In the meantime, the property owners couldn't do anything with the property.
That's exactly right. In conclusion, Your Honors, this is a classic presentation of a board hearing competent material and substantial evidence from an applicant. It became entitled to its permit because of its evidence, but the board instead based its decision upon the speculations, the generalized fears, the hypotheses, and the opinion testimony of lay witnesses. We ask you to overturn this decision and order the permit to be issued because under the law in North Carolina, the applicant was entitled to it. And we will reserve the rest for rebuttal.
Okay, any questions? Any questions?
So, thank you.
Okay, thank you. Thank you, Mr. Terrell. We'll retain whatever remains for your rebuttal. Ms. Huffman? Good afternoon.
Good afternoon. Good afternoon, judges. My name is Sharon Huffman. I'm here on behalf of New Hanover County and the New Hanover County Board of Commissioners. As Mr. Terrell said, the applicant did provide good initial evidence, and I conceded to that fact during the Superior Court hearing. They had sufficient evidence to establish a prima facie case. They had a favorable traffic impact analysis. They had an engineer who proudly touted a 100-year stormwater pond. They had an appraiser who determined that there was not any negative impact to the value of adjoining properties. And they established their prima facie case. But then the commissioners heard the rest of the story.
But how is let's cut to the traffic here for a minute. How is this case any different than the McLam versus Smithfield case that was handed down in June of 2019?
And,
How is the evidence any different?
and will you tell me exactly what you're referring to in that case, sir?
I'm referring to the part of that case where I wrote, and that lay testimony is not competent evidence.
Yes, sir.
And there's nothing in the traffic study that I see that your clients presented that's anything but lay testimony, is there?
Yes, sir. And certainly that's what the applicant has argued throughout, and until this day, they continue to argue, and I take it that until you're convinced differently, that it's your suggestion at this point that the testimony from the opposition regarding the traffic on this unsafe road is not competent because it was not expert, and there were no expert witnesses on behalf of the opposition. And so I would suggest to you that there's going to need to be an interpretation of that section of 160A 393, where it says that evidence regarding the volume of traffic and whether it can be used towards public safety issues requires an expert. But clearly, the situation here doesn't have anything to do with volumes of traffic on a roadway as that traffic is moving along. In many, many special use permits, we have traffic engineers who testify about the volume of traffic at a certain speed on a certain roadway and whether that endangers the public. We have traffic engineers who testify about the volume of traffic at a certain speed at a certain intersection and whether that endangers the public. We have engineers who testify about the volume of traffic at a Michigan turn and whether an increase in volume is going to endanger the public. And I would even suggest that we could look to the witness in the PHG case who came up to the podium and said, I'm not here in favor or against, I'm just interested. And I'm just interested in whether this site, the site issue that he brought up during the PHG case, well, one could immediately say or question, well, if that person, when they came up to the podium, if they had said, well, I'm here in opposition, and I want to ask about the site, whether you can see over this hill, or whether you can see around this curve, whether that would have made a difference to the court. And my answer to that is clearly no, because that's exactly the type of evidence about traffic issues that this statute should apply to.
But the statute specifically says that lay testimony is not competent, does it not?
It does say that the evidence regarding volumes of traffic and whether it can be used in the endangerment of public health and safety is incompetent. But again, what I'm suggesting is the testimony in this case isn't about the volume of traffic and whether it endangers the public at an intersection or at a turn or on a roadway. All they are talking about is that this particular roadway is the access into this project. And this roadway is crumbling, and it's full of potholes. And you can see the potholes just as you're going into the project. And any cars that are going to be added to that unsafe, dangerous road certainly contributes to the public health and safety. And what I'm submitting to you, Judge, is that that is a completely different situation from what this statute intends. And again, I believe that this court would need to distinguish this type of evidence from the type of evidence that the statute intended to be applied to.
So you think the intent is that somebody, you get a string of lay witnesses come up and can effectively block somebody from using their property based off lay testimony of any kind?
I'm sorry?
You're saying that there's lay witnesses come up and testify about traffic patterns, right?
Yes.
So there's no standard, there's no qualification. They can block these people from using their property based off that testimony alone. And that's not, and you're saying the legislature didn't intend for there to be a standard by that statute.
Well, I don't think the legislature intended for this section of 168-393 to be applied to every single solitary situation that involves traffic on a roadway. I believe, and again, I think you would need to distinguish that this particular situation is not about how the volume of traffic moving on a roadway at intersections and turns and speed issues endangers the public. It's simply that as each one of those hundreds of cars left this project each day and ran through that pothole a few feet from the entrance into the project, that endangers the public health and safety. And I don't think it takes a traffic expert to understand that. That, to me, seems commonsensical.
My question, and we have seen a kind of common thread in these cases, on special use permits, the statute clearly requires a quasi-judicial hearing, not a legislative hearing. Evidence on the record, impartial decision maker, no ex parte communications. It is a judicial proceeding.
Yes, sir.
And one side presents its evidence. They've got 4 criteria to meet. If they meet it, prima facie, they're entitled to use, and the burden shifts to the opposing party to show evidence contra. When you ask about a layperson coming up to testify about the condition of the road, there's nothing to prevent the commission or from the layperson to pose a question to the applicant's expert. Isn't it true that there are potholes there? Isn't it true the road needs repair? So, I mean, there's a procedure in a quasi-judicial hearing for the expert's testimony to be challenged, either by the commission, by the staff, or by the witnesses. But just someone coming up saying there's potholes in the road, or my property flooded during a hurricane, to rebut, sworn testimony by an expert. That's the question. That's the problem we have. And I've been on public boards. I've been on planning boards. And I know when you have a bunch of screaming people in the audience, particularly if you're an elected official, you tend to respond to the riot, if you want to call it that. But that's not, you can't allow that in a quasi-judicial hearing. So my question is, knowing that's the procedure that we're under here, and once you've admitted that they made their prima facie showing, the statute requires to rebut that there be competent material evidence. And I guess my question is, how can the county show that? And I'm not sure you were the county at the hearing, and I want to ask about why this was delayed 6 months too.
Yes, sir.
So my question goes is, it looks like the commission were advised, as we said in Asheville, that county council, city council has a duty to remind the elected body of the type of proceeding they're in and to advise them. It appears that the county attorney advised the board, and notwithstanding that, they went and basically made a decision that was contrary to the evidence, to the admitted evidence before.
Let me speak very briefly to what you said about the applicant's engineer and what they would have reported and whether it was rebutted. The fact of the matter is that the traffic impact analysis did explain that the roadway was, as they said, at the end of its design life. I don't think that anybody really questioned the dangerous condition of the road. Everyone just assumed that it was about to be repaired. And that's one of the things that happened that I think spoke volumes to the commissioners, that at the initial hearing in October, the suggestion that was made to the board was that this roadway, which was a private roadway until just a very short time before, and it was just a small, narrow neighborhood road that had been there forever and used by all these dozens of neighborhoods, and again, crumbling, full of potholes. And then the DOT took it over because their plan was that it was going to be used as a connection to a bypass that's being constructed. And the suggestion to the commissioners at that first hearing was, it's going to be repaired soon. It's going to be enlarged and improved and repaired soon. And so at the end of the evidence that was presented during the first hearing, the commission began to ask questions of staff and the applicant about, well, when is it going to be repaired? Because obviously it's in a dangerous condition right now. Is it going to be repaired in the next few months? And a suggestion was that we think so. And so one of the two reasons that the commissioners stated that the matter was to be recessed and continued was to find out if the road was going to be repaired sometime soon. They wanted to recess for 6 months, but the applicant, during a debate about how long it's going to be recessed for, seemed to suggest, well, 90 days is okay. So it was recessed for 90 days. Of course, then some different things happened, including COVID, and it ended up being 8 or 9 months before we came back for the second hearing. And at that second hearing, the representative there from the DOT was asked by the commissioners, well, it's not been repaired yet. When is it going to be repaired? And the DOT rep stated, well, no, it hasn't been, and it's not going to be anytime soon. Our expectation is that it's going to be repaired, enlarged and repaired, when we're ready to connect to the bypass, which we expect to happen by the end of 2023. And so we're talking 3 years out from the commissioner hearing, And I think that did speak volumes to the commissioners at the time that they made the decision is, well, we were thinking maybe it was going to already be repaired. That's why we waited. And now it's going to be 3 more years. And I think that was very, very important to them. And if I could,
Is the property owner's right to make an affirmative use of their property dependent upon the timing of off-site public improvements?
generally, certainly no, Your Honor. And part of the applicant's contention is that because of these pre-existing conditions, that all of this evidence that was presented is not material. It's not their fault that there were pre-existing conditions. It's not their fault that there was an unsafe road. It's not their fault that many homes in the surrounding neighborhoods flooded during the 2 hurricanes just before this hearing. We understand it's not their fault, but as the Superior Court judge said, this project, which has a standard to meet, that it will not materially endanger the public health and safety, as the Superior Court judge said, it's a component of the community where it's sited. We're talking about...
But you've conceded that they met the prima facie case.
Yes, sir.
That you conceded that.
Yes.
And then the burden shifted to the opponents to offer material evidence. And I would contend to you that that material evidence had to be expert testimony with respect to traffic.
Yes, sir.
As I read the statute, and as the cases have, since the statute have said, and your client did not have any material evidence from any expert in front of them regarding the traffic and the danger. You're saying, well, it's dangerous and everybody knew it. If that's the case, then why couldn't the opponents have brought an expert in and a PEN or someone to, or a traffic study person say, oh no, this road, but they did not.
Yes, sir.
And they did not cross-examine the other expert to get them to say that either, did they?
No, sir. And all I can respond again with regards to that is, it's my belief that this is not the type of situation that the legislature intended for that to be applied to, and that again, it seems to me that it would be obvious to everyone that the hundreds of cars leaving this site and running into the pothole that's just outside its entrance would be clearly a danger to public health and safety, and that an expert's not needed for that. But if I may, I'd like to move on to the question that was asked about the materiality of this evidence as it relates to the pre-existing problems, not only of the traffic issue, but of the flooding issue. The hearing that took place in October of 19 was a couple of months after a hurricane. And it was a year after the previous hurricane. We have a lot of hurricanes in New Hanover County. As I said, the engineer proudly talked about their 100-year stormwater pond.
Let me ask you this, was the standard in the ordinance that the property owner would have to account for a 25-year flood?
Yes.
So that's all he had to show in order to show entitlement, correct?
It's all that New Hanover County requires from engineering.
So given the fact that it was common knowledge of the flooding from whatever source, the Hurricanes or whatever, Cape Fear River, whatever it is, isn't it reasonable to presume that the expert anticipated that he had to do more than meet the minimum, and that he did that by going from a 25-year flood level to a 100-year flood? And then on top of that, as I remember the record, during the staff review, they additionally offered to change the drainage from one watershed to another to take pressure off the Ogden watershed. and actually put a pipe under Market Street, US Highway 17. That's no small thing, to put a pipe, to actually take the water from one watershed to another. I mean, that to me is what the evidence was before the commission.
This particular site is certainly and I'm trying to respond to your question in a roundabout way. This particular site has been vacant forever. To my knowledge, there's never been anything there, and maybe with good reason. It's at the absolute intersection of three creeks. And it's my belief that the applicant's engineer knew they were dealing with a problem area, knew they were dealing with surrounding neighborhoods that flooded every time there was a storm because they'd had a community meeting and they had heard about it. And I think they understood that they needed, if they were to be looked at favorably, to provide for the 100-year stormwater pond, and they did that willingly. And it's something that we're seeing on a regular basis in New Hanover County because of the flooding issues. But the problem here in this particular case is that, again, as I said, there had been 2 hurricanes, 2 100-year storms within a year of this hearing. The dozens of folks who lived in these surrounding neighborhoods came to the hearing and they told the commissioners, well, every time there's a hurricane, and we've had 2 in the last year, and we don't know if there's going to be another one next month or next year, but every time there's a hurricane, which is a 100-year storm, most likely, every time there's a hurricane, our streets and our yards and our homes flood. And we know that next month or next year when there's a hurricane, we know that this 100-year stormwater pond that the applicant is proudly telling you about is not going to hold that stormwater.
But they didn't offer any expert testimony to that, did they?
They did not offer any expert testimony regarding that. Again, Judge, I would suggest to you that a bowl that overflows is going to overflow.
Did they cross-examine the plaintiffs or the applicant's expert? Did they challenge his?
There were certainly questions of the applicant's expert about his analysis, because there were witnesses that asked questions, that made suggestions that we know all of us can take public notice of, that we have 100-year storms here on a regular basis.
So the board, knew the standard, and then they broke for what, 8 or 9 months between when they made the decision or we had the hearing. So in that interim, was there any talk of hiring an expert? Or, I mean, was there, I guess, were they relying on the lay testimony? Was that convincing enough for them?
Well, I can't speak to whether there was additional thought from anyone about hiring, whether the opposition would hire experts, but again, the other reasoning for the continuance, the recess and continuance, was to see what was going to be done about the deficient stormwater infrastructure, because during that first hearing, the commissioners questioned at length the county engineer, questioned the applicant's engineer and the county engineer about, well, we've obviously got severe flooding issues in the neighborhoods that are right beside this proposed project. What are we doing about it? Because we can't allow, every time there's a storm, for these homes to flood. And the county engineer told the commissioners at that initial hearing that there was a loan that they were expecting to receive from the federal government to clean out the hurricane debris from these 3 creeks. He explained to the commissioners that there was a pending county program called a stormwater abatement program, where the county was going to take over the burden of cleaning out ditches and doing the necessary things to improve this deficient stormwater infrastructure in these surrounding neighborhoods. And so another part of the reasoning of the commissioners in continuing this, I believe they said exactly motion to continue so that the commissioners can receive further information on the repair of this road and the improvement of the deficient stormwater infrastructure.
And ma'am, your client, the county, has a series of professional people and engineers and stormwater folks that they hire and that are on staff. Is that correct?
Yes, sir.
And did any of those professionals offer an opinion that this should not be allowed?
That
This project should not be allowed or should not be approved? That this special use permit should not be approved?
there was not any staff person who stated to the commissioners that the project should be denied.
And in fact, isn't it a fact that the staff had approved it all the way up to the commissioners?
Well, they had, in some way, recommended that approval. Yes, sir.
And they are professionals, and they are the professionals who know about the flooding and know about the roads and know about all of that. And you have all those professionals on staff, isn't that correct?
Yes, sir.
And they had recommended approval, isn't that correct?
Yes, sir.
Thank you.
Now, let me ask you this, since, off-site improvements, public improvements, this applicant's been delayed 9 months. We know what's happened to cost of development. We know what's happened to the cost of money. I mean, the county's inflicted serious cost on this applicant just by the delay. And the Supreme Court, our U.S. Supreme Court has said that if you, in effect, do a ban on development, even temporary, that's a taking. So, I mean, do you agree it's the county or the government's burden to provide public infrastructure?
Well, to some degree, it is.
Well, and the DOT was the organization, state agency to maintain and improve these roads and to bring them up to standards if they were deficient.
Yes, sir.
And if there was a stormwater deficiency there, from the hurricanes to clean out the ditches or whatever, that was a public duty to do that.
Well, it was going to become a public duty. At the time of this hearing, that was not the case.
Well, if it was going to be a public duty when the money came, it was a public duty when it occurred. The fact there might not be funding there from a particular source does not change the nature. It was not the owner's obligations to clean that out, it was the city or the county.
It was not the obligation of this applicant to fix the road or to clean out the ditches.
So on what legal basis can you deny a property owner? The county's got a duty to protect the property owner's rights too. You agree with that?
To some degree, yes, sir.
Okay, and when you have a compliant permit by a property owner to develop a property within the confines of the ordinance, isn't there some obligation for the county or the government to make sure that those rights are protected as well?
Well, if I certainly understand and agree with your philosophy, Judge.
No, I'm asking a question. It's not a philosophy. It's that you've got a property owner that wants to make an affirmative use of their property. They've met all the ordinance conditions, and yet they're delayed and denied in doing that for reasons unrelated wholly to their application before the board.
Well, that's where there's a reasonable conflict, Judge. It was the opinion of the commissioners and then the opinion of the Superior Court judge that that they had not met their burden. They did initially, but it
But
was.
once they meet the burden, then there's a shift to the opponents.
Yes, sir.
So if they met the burden, they've met the burden.
They established their prima facie case, and the Superior Court judge then determined that the opposition evidence was competent, was material, and was substantial, and that there was a reasonable conflict in the two sets of evidence. And the Superior Court judge quoted from the Fourth Circuit, as Dave Owens quoted from the Fourth Circuit in his most recent land use law book that came out a few months ago. And the Superior Court judge and Professor Owens both quoted from the Fourth Circuit that said when there's this reasonable conflict, and understand, Judge Arrowood, you're suggesting that there's not a reasonable conflict because, in your opinion, they haven't met that standard of competent, material, and substantial. But if you determine that the evidence, all of that evidence that came in from the opponents was competent, material, and substantial, as the Superior Court judge did, and I think he said it was sufficiently trustworthy, and it was based on their personal knowledge and observations, and it did not require an expert, and therefore he believed that it was competent, material, substantial, and that weighing the two differing sets of evidence, that he could not replace the board's decision even if he would have determined differently, and even if you would determine differently, and even if I would.
Well, but we
determine
get to
differently.
determine whether it was competent evidence, though, don't we?
Yes, sir.
And we review that judge's decision de
Yes, sir.
novo. And also the board's decision as well,
Yes, sir.
because we're in the same position as the Superior Court. The Superior Court is acting as a court of review, not a court of fact-finding. Do we agree on that?
Yes, sir.
Okay.
And so I would submit to you that what you have in front of you is exactly the type of case that the Fourth Circuit was talking about in the AT&T versus Winston-Salem case.
But you're aware the Fourth Circuit is not binding authority in this court either.
Yes,
aren't
sir.
you, ma'am?
Yes, sir.
I'll give you a moment to sum up if you'd like.
Again, you're all familiar with the PHG case. I've read your opinion several times. I've read the Supreme Court opinion several times. Obviously, this case is very clearly distinguishable because in the PHG case, there was zero opposition evidence and therefore zero contra evidence. In this case, there's volumes of opposition evidence. You, as a Superior Court judge did, must determine what parts of it were competent, what parts were material, what parts were substantial, and if you're able to determine that it was sufficiently trustworthy and it was based on the personal experiences and observations of these opposing witnesses, and that it was sufficient to show that perhaps this prima facie case did not meet the burden required of the ordinance, that this project, as a component of the community, and that's again what the Superior Court judge kept harping on, it is a component of the community. No, they didn't cause these pre-existing problems, but it is sited at this place, at this time, where there's an unsafe road that it will send its hundreds of cars out on. It's sited at a place next to houses that will flood the next time there's a hurricane until deficiencies are remedied. The Superior Court judge stated I have weighed those things, and as the Fourth Circuit said, I must accept the fact that the board made a decision that they believed that was correct, and unless there's some problem other than what we know about here, I cannot replace their decision.
Thank you.
Thank you.
Mr. Terrell?
Just 2 points, Your Honor. The PHG versus City of Asheville case was used as some form of precedent for allowing lay testimony on the issue of traffic. I litigated that case before 3 courts. I know a lot of what was in that record. That's not what the courts have said, number one. And number two, that case actually illustrates the problem with lay testimony in these cases. At the end of all of the testimony, a man walked in to the city council chambers and says, I'm not for it and I'm not against it, but have you considered that for traffic exiting where this hotel exit would be, that there's a blind hill up here? There was no evidence as to what a blind hill means. There was no evidence as to what the distance was. There was no evidence as to what distance there would have to be for it to be safe. There was no evidence on the incline. There was nothing about the speed and how the design speed as well as the actual speed and how well that would have been a factor. But when the board was deciding what their findings would be, Council Member Cecil Bothwell says, oh yes, and I want it to be in the record that there's a blind hill right there. And I think our courts have appropriately said that in that case, that was not evidence. Now, as to
Did we
whether-
have the same type of testimony in Lee County?
in the Little River case?
Yes.
We had a lot of that same testimony in Little River.
And was the holding of the court consistent that expert testimony is required?
That is
Late-
correct.
I mean, is there any case since the change in the statute that would support the county's decision that
There
you're
is
aware
not
of?
a single case. Every single case that has been decided affirms the statute. It affirms what we're bringing to you today, that it requires expert testimony and something that's competent, material, and substantial. The final point is you don't get to interpret 160A-393 where it's abundantly clear, and that's King versus Chapel Hill, when a statute is clear and unambiguous on its face. You don't interpret it, you apply it. Thank you for your time.
Hold on a minute. You have any other questions?
I'm set, thank you.
You have any other questions? Okay. Thank you, Mr. Terrell, for your arguments. The case is submitted. We appreciate good arguments from both sides, and thank you for your appearances. And Mr. Clerk, will you adjourn court, please?
All rise. Court adjourned. Which one did I stop first?
Stop that one first.
Okay. See right here, right? Okay, let's see. I'm gonna stop streaming. You can see they're gone, so you can stream.